If you are 65 or older, or if you have a parent or grandparent in a nursing home, a hospital, a funeral home, or any kind of care facility, what I am about to tell you could save you thousands of dollars. Because there are fees being charged to seniors every single day in America that are completely illegal, not just unfair, not just excessive, illegal under federal law, and the people charging these fees are counting on the fact that you don't know that. They are counting on you signing the paperwork without reading it. They are counting on you trusting the institution. They are counting on your grief, your urgency, your exhaustion in a moment of crisis to slip these charges past you. It is happening to millions of American seniors right now. And today I am going to name 7 specific categories of fees that you may have already paid, that you should refuse to pay, and in some cases, that you may be entitled to get back. Are you subscribed? Because this is exactly the kind of information that should be reaching every senior in America. Hit that subscribe button right now because I do not want you or anyone you love to pay one more dollar they don't owe. Let me start by telling you something that sets the stage for everything I am about to explain. In December 2025, the Federal Trade Commission issued its annual report to Congress on protecting older consumers. The report documented massive ongoing fraud and illegal fee practices targeting seniors across housing, healthcare, financial services, and consumer goods. The FTC, which is the nation's primary consumer protection agency, identified undisclosed fees for senior housing as one of the top enforcement priorities. That means the federal government itself has confirmed that illegal fee practices targeting seniors are widespread, ongoing, and being actively pursued. What I am going to walk you through today are the 7 most common categories of illegal fees that seniors and their families encounter. I will tell you what the fee is, what law makes it illegal, what you should do if you encounter it, and how to report it and potentially recover what you've paid. Fee number 1. Nursing homes requiring family members to personally guarantee payment as a condition of admission. This one is perhaps the most widespread illegal fee practice affecting seniors in America right now, and it is the one that can cause the most financial devastation. Here is what happens. Your parent or spouse needs to go into a nursing home. You go to the facility for the admission meeting. You are handed a thick stack of paperwork. You are emotional. You are stressed. You are in a hurry to get your loved one situated and safe. Buried in that paperwork, often in dense legal language, is a clause requiring you, the family member, to personally guarantee payment of the nursing home costs. You sign it because you don't know you don't have to. You assume it's just standard paperwork. And then, if your loved one's Medicare or Medicaid runs out or is denied, the nursing home comes after you. They sue you. They get a judgment against you. They garnish your wages. They can come after your home. Families have been bankrupted by this. Here is what the law actually says. The Nursing Home Reform Act, a federal statute, explicitly prohibits nursing homes that participate in Medicare or Medicaid from requiring a non-resident to personally guarantee the cost of care as a condition of admission, expedited admission, or continued stay in the facility. That prohibition is absolute. It applies to all residents regardless of whether they are on Medicare or Medicaid, even if the resident pays privately. The prohibition still applies because the facility participates in the Medicare and Medicaid programs. In November 2024, the Centers for Medicare and Medicaid Services issued new guidance making this even clearer. CMS clarified that various nursing home attempts to evade this prohibition through clever contract language are illegal. That guidance was directed at all nursing homes and took effect in April 2025. In a 2022 joint report, the Consumer Financial Protection Bureau and CMS confirmed that 75% of surveyed nursing home admission agreements contained clauses that appeared to make family members liable for costs. 75%. That is how widespread this illegal practice is. What should you do? First, before you or your loved one signs anything at a nursing home, read every line of the admission agreement. If you see language making you personally responsible for costs, cross it out. If the nursing home says you have to sign it, or your loved one won't be admitted, that is itself a violation. Second, if you have already signed an agreement with an illegal personal guarantee clause, that clause is unenforceable. Courts have repeatedly held that these clauses violate federal law and cannot be enforced. Third, if a nursing home or a debt collector is trying to collect from you based on one of these illegal clauses, you have defenses. Contact a consumer law attorney immediately. You may also have claims against the nursing home and the debt collector. The Fair Debt Collection Practices Act prohibits debt collectors from trying to collect debts they know are not legally owed. Trying to collect on an unenforceable nursing home guarantee clause violates the FDCPA. File a complaint with the CFPB and your state attorney general. If you're finding this valuable, please subscribe right now. Because I cover these consumer protection issues every week, and most of my viewers tell me they had no idea about any of these protections before they found this channel. The subscribe button is right there. Hit it now. Fee number 2. Medicare balance billing. This one costs seniors billions of dollars every year, and it is overwhelmingly illegal. Here is how it works. You go to a doctor who accepts Medicare. Medicare pays the doctor a set amount for your care, called the Medicare approved amount. The doctor may have what's called an assignment agreement with Medicare, meaning they agree to accept the Medicare approved amount as full payment. But then you get a bill for an additional amount beyond your copay and deductible. That additional charge, beyond what Medicare allows, is called balance billing, and in most cases, it is illegal. Under Medicare law, participating providers, which are providers who have signed agreements with Medicare, cannot charge you more than the Medicare approved amount plus your standard cost sharing, like deductibles and copays. If a provider has agreed to accept assignment and then balance bills you above the Medicare rate, that is a federal violation. They can face civil money penalties and be expelled from the Medicare program. There are some limited circumstances where balance billing is allowed. Non-participating providers who have not signed Medicare assignment agreements can charge more, but they are still limited. They can charge up to 15% above the Medicare approved amount. This is called the limiting charge. Anything above that 15% limit is also illegal. If a provider has opted completely out of Medicare, meaning they have filed a formal opt-out agreement with Medicare, they can charge what they want, but they must tell you up front that Medicare won't pay, and you must sign a private contract acknowledging this before receiving care. Most providers have not opted out of Medicare, so when you get a bill that exceeds what Medicare has said you owe, scrutinize it carefully. What should you do? First, when you get an explanation of benefits from Medicare, compare it with any bill you receive from the provider. The Medicare EOB shows what Medicare paid and what it says you owe. If the provider is billing you more than the EOB says you owe, that could be balance billing. Second, call the provider and ask them to explain the additional charge. Ask them whether they are a participating Medicare provider. Ask them to show you their assignment agreement. Third, if you believe you've been illegally balance billed, contact Medicare directly at 1-800-MEDICARE. You can also contact your State Health Insurance Assistance Program, known as SHIP. They provide free counseling to Medicare beneficiaries about billing issues. Fourth, file a complaint with Medicare if you identify illegal balance billing. Medicare takes these complaints seriously because fraudulent billing costs the program billions. Fee number 3. Funeral home hidden fees and package-only pricing. If you have ever arranged a funeral for a loved one, you know how vulnerable you are in that moment. You are grieving. You are overwhelmed. You are trying to make dozens of decisions while barely functioning. Funeral homes know this, and some of them exploit it with hidden fees and illegal pricing practices. Here is what the law says. The FTC's funeral rule has been in effect for decades. It requires funeral homes to give you a written general price list when you first ask about funeral arrangements, or when you visit in person. They must itemize every service and product with individual prices. They cannot require you to buy a package deal if you don't want to. You have the right to pick and choose exactly the services you want and pay only for those. One of the most commonly violated provisions of the funeral rule involves caskets. If you purchase a casket from a third party, perhaps online or from a casket warehouse, the funeral home must accept it. And here is the critical part. They cannot charge you a handling fee or a surcharge just for using a casket you bought elsewhere. This casket surcharge is explicitly prohibited by the funeral rule. Funeral homes routinely try to charge extra fees when families bring in third-party caskets. They call it a delivery fee, a preparation fee, a container acceptance fee, or any number of names designed to obscure what it actually is, an illegal surcharge for not buying from them. If a funeral home charges you an extra fee solely because you provided your own casket, that fee violates federal law. Similarly, the funeral rule prohibits funeral homes from charging for embalming without your permission and without telling you that embalming is generally not required by law. Many families are charged for embalming they never requested and didn't need. Embalming is not legally required in most states for most types of services. Charging for it without explicit permission is illegal under the funeral rule. The FTC has been actively enforcing the funeral rule, with funeral-related enforcement actions documented in their annual reporting as recently as 2025. What should you do? When you go to a funeral home, ask for the general price list immediately. They are required to hand it to you before you discuss anything else. Review every line item. Refuse package deals if you don't want them. Know that you can bring your own casket, and they must accept it without surcharges. If a funeral home violates the funeral rule, report them to the FTC at ftc.gov/complaint. Hey, 73% of people watching right now are not subscribed. If you want to stop paying fees you don't owe and protect yourself and your family, this channel exists for exactly that purpose. Subscribe now and join the community of seniors and caregivers who are taking back control of their finances. Fee number 4. Hidden fees on event tickets and hotel stays banned by the new FTC junk fees rule. On May 12, 2025, a new federal rule took effect that protects every consumer in America, including seniors, from a specific category of illegal fees. The FTC's rule on unfair or deceptive fees, commonly called the junk fees rule, prohibits businesses that sell live event tickets and short-term lodging from advertising one price and then charging another price after hidden fees are added. This is called drip pricing or bait and switch pricing, and as of May 12, 2025, it is illegal. Under the new rule, any business selling concert tickets, sporting event tickets, theater tickets, hotel rooms, vacation rentals, or short-term lodging must display the total price, including all mandatory fees, up front. They cannot hide resort fees, amenity fees, cleaning fees, service fees, or any other mandatory charge until the final screen of checkout. The fee must be included in the advertised price. Period. Why does this matter specifically for seniors? Because seniors are among the most frequent targets of deceptive pricing practices. Seniors often travel to visit family, attend events, and take vacations on fixed incomes where every dollar counts. Being surprised by a $50 per night resort fee or a $35 service charge on a concert ticket can genuinely damage a senior's budget for the month. Before May 2025, these hidden charges existed in a legal gray area. Now they are explicitly prohibited. If you book a hotel or event tickets and you are charged a fee that was not clearly disclosed in the total price from the beginning of the transaction that may violate the junk fees rule, you can report violations to the FTC at reportfraud.ftc.gov, and the FTC can take enforcement action against businesses that violate the rule, including requiring refunds for illegally collected fees. Fee number 5. Surprise medical bills. This category affects virtually every senior who has had a hospital stay, an emergency room visit, or an outpatient procedure in the past few years. Before January 2022, surprise medical billing was rampant. You would go to an in-network hospital and then receive a massive bill from an out-of-network anesthesiologist or radiologist or assistant surgeon who happened to be working in that hospital but was not in your insurance network. You never chose that provider. You didn't know they were out of network, and yet you were stuck with a bill that could run into thousands or even tens of thousands of dollars. The No Surprises Act, which took effect in January 2022, banned this practice. Under the No Surprises Act, for emergency services, you can only be billed the in-network cost-sharing amount, meaning your in-network deductible and copay, even if the provider is out of network. For non-emergency services at an in-network facility, out-of-network providers at that facility cannot surprise bill you either, with some exceptions. If an out-of-network provider wants to bill you at out-of-network rates for non-emergency services at an in-network facility, they must give you advance written notice, in plain language, that they are out-of-network, and that you may be billed at out-of-network rates. And you must sign a consent form acknowledging that you understand and agree to this. If they bill you at out-of-network rates without going through this consent process, that is a violation of the No Surprises Act. Yet surveys have found that surprise billing in violation of the No Surprises Act is still occurring at significant rates. Providers and hospitals are either unaware of the requirements or are deliberately ignoring them, counting on patients not to know their rights. What should you do? When you receive a medical bill that seems surprising or excessive, compare it with your insurance company's explanation of benefits. If you see out-of-network charges for care you received at an in-network facility, and you never signed a consent form agreeing to out-of-network billing, contact your insurance company and dispute the bill as a potential No Surprises Act violation. You can also submit a complaint to the Centers for Medicare and Medicaid Services at nosurprises.cms.gov. There is a federal complaint process specifically designed for No Surprises Act violations. Do not simply pay a surprise medical bill because it arrived. Question it first. Fee number 6. Undisclosed fees in senior housing and assisted living admission agreements. This one was specifically called out in the FTC's December 2025 report to Congress as a priority enforcement area. When seniors or their families sign admission agreements for assisted living facilities, memory care units, or other senior housing facilities, they are frequently confronted with a blizzard of fees that were never disclosed in the marketing materials, the price sheet, or the initial tour of the facility. Community fees paid upfront and not refundable when the resident leaves. Move-in fees disguised as processing charges. Fee increases imposed without adequate notice or contractual justification. Additional charges for services described during tours as included in the monthly rate. Personal care fees assessed at levels that were not disclosed or were misrepresented during the sales process. Under federal and state consumer protection laws, including the FTC Act's prohibition on unfair or deceptive acts and practices, misrepresenting the total cost of senior housing is illegal. The FTC has been documenting and pursuing cases involving undisclosed fees in senior housing, and several state attorneys general have brought enforcement actions in this space as well. The 2025 FTC report specifically highlighted undisclosed fees for senior housing as an area of significant concern and active enforcement. What should you do? Before signing any senior housing agreement, get a complete written list of every fee you will ever be charged, including the circumstances under which fees can be increased, how much notice must be given before increases, and what happens to any upfront fees if the resident leaves or passes away. Get everything in writing. Do not accept verbal assurances. And if a facility charged you fees that were not disclosed in writing before you signed the agreement, you may have a valid consumer protection claim. Contact your state attorney general's Consumer Protection Division. Fee number 7. Unauthorized or excessive debt collection fees targeting seniors and their families. This final category encompasses a broad range of illegal fee practices that occur primarily in the debt collection context, and seniors are disproportionately targeted. Under the Fair Debt Collection Practices Act, debt collectors cannot add fees or charges to a debt that are not expressly authorized by the original agreement or permitted by law. Yet debt collection companies regularly inflate balances with collection fees, attorney fees, or administrative charges that are not legally authorized. They count on the debtor not knowing what the original amount was or what the collector is allowed to add. For seniors specifically, there are several additional protections worth knowing. First, the Nursing Home Reform Act provision we discussed in FE number 1 creates a specific category of debt that is not legally owed by family members. When a debt collector tries to collect that nursing home debt from a family member, and the underlying guarantee clause is illegal, the entire collection effort is based on an unlawful premise. Under the FDCPA, collecting a debt that is not legally owed is itself a violation of federal law. Second, Social Security and federal retirement benefits have special protections against garnishment. Debt collectors cannot garnish Social Security benefits, veterans benefits, federal retirement benefits, supplemental security income, or certain other federal benefit payments to pay most consumer debts. This protection exists even after a debt collector gets a court judgment against you. If a debt collector is threatening to garnish your Social Security or federal pension check, that threat may itself be illegal under the FDCPA. Third, medical debt has received significant protections in recent years. Under rules that took effect in 2025, medical debt under certain thresholds can no longer appear on credit reports in the same way it previously did. Medical debt collection practices targeting seniors have been a specific focus of CFPB enforcement. If you are being harassed by debt collectors over medical bills, know that you have rights under the FDCPA, including the right to demand validation of the debt in writing, the right to dispute the debt, the right to require that the collector stop contacting you, and if the collector is violating the FDCPA, the right to sue them and potentially recover damages plus attorney fees. Now let me give you a comprehensive set of action steps you can take right now. The first and most important thing is to stop paying any fee you haven't verified is legitimate before you question it. Do not assume that because someone is billing you, you owe it. Billing is not proof of a legitimate debt. The second step is to keep every financial document related to your care: nursing home admission agreements, hospital bills, Medicare explanations of benefits, funeral home receipts, assisted living contracts, debt collection letters. Keep all of it. These documents are your evidence if you need to dispute a charge or file a complaint. The third step is to use the Medicare online tools. If you are a Medicare beneficiary, you can review your Medicare statements online at medicare.gov. Review them regularly. Look for charges for services you didn't receive or amounts that don't match your provider bills. Medicare fraud costs the program billions annually, and your careful review helps catch it. If you see something that doesn't add up, call 1-800-MEDICARE. The fourth step is to contact your state health insurance assistance program. SHIP counselors provide free, unbiased assistance to Medicare beneficiaries. They can help you understand your bills, identify potential billing errors, and file complaints. Find your local SHIP program at shiphelp.org. The fifth step is to know your complaint options. For nursing home fee violations, report to your State Department of Health and the CMS Regional Office. For Medicare balance billing, report to Medicare at 1-800-MEDICARE. For funeral home violations, report to the FTC at ftc.gov/complaint. For junk fees on tickets and hotels, report to the FTC at reportfraud.ftc.gov. For No Surprises Act violations, report to CMS at nosurprises.cms.gov. For FDCPA violations, report to the CFPB at consumerfinance.gov/complaint. For senior housing hidden fees, report to your State Attorney General's Consumer Protection Division. The sixth step is to consider consulting an attorney for larger amounts. If you have paid thousands of dollars in illegal nursing home guarantee fees, suffered significant harm from Medicare balance billing, or been subjected to systematic illegal debt collection, a consumer law attorney may be able to help you recover those amounts. Many consumer protection attorneys work on contingency, meaning you pay nothing unless they recover money for you. Let me also address something that comes up frequently in these conversations: the emotional barrier to challenging these fees. Many seniors tell me they feel embarrassed to dispute a bill or challenge a fee. They worry about seeming difficult or ungrateful. They don't want to make waves, especially when dealing with a nursing home or hospital where a loved one's care depends on having a good relationship with the staff. I understand that feeling completely. But I need you to hear this clearly. Disputing an illegal fee is not making waves. It is exercising a legal right that Congress and federal regulators have explicitly protected for you. The people who put these illegal clauses in their contracts are the ones making waves. You are simply refusing to pay money you don't owe. There is also an important distinction between the clinical staff who care for your loved one and the billing department of the same facility. Your loved one's care does not depend on whether you dispute an illegal fee in the billing office. Those are completely separate functions. The nurse who provides your loved one's medication does not know or care whether you signed an illegal personal guarantee clause. Dispute the billing. Protect the relationship with the care team. Those are not the same thing. Here is something else I want you to know. The organizations that can help you are free. Your SHIP counselor is free. Your state long-term care ombudsman is free. The CFPB complaint process is free. Legal aid organizations for seniors are free for those who qualify financially. You do not have to hire an expensive lawyer to dispute most of these fees. Start with the free resources. They are more powerful than most people realize. Let me recap the 7 illegal fees you need to watch for. Fee 1, nursing home personal guarantee requirements from family members, prohibited by the Nursing Home Reform Act. Fee 2, Medicare balance billing above the approved amount by participating providers, prohibited by federal Medicare statute and regulations. Fee 3, funeral home casket surcharges and unauthorized embalming charges, prohibited by the FTC funeral rule. Fee 4, undisclosed junk fees on event tickets and hotel stays, now prohibited by the FTC junk fees rule, effective May 12, 2025. Fee 5, surprise medical bills from out-of-network providers at in-network facilities without prior written consent, prohibited by the No Surprises Act effective January 2022. Fee 6, undisclosed fees in senior housing and assisted living contracts, prohibited under federal and state consumer protection laws. Fee 7, unauthorized collection fees and improper garnishment of federal benefits, prohibited by the Fair Debt Collection Practices Act. These are real laws. They have real teeth. They are enforced by federal agencies with the power to impose penalties, require refunds, and pursue legal action against violators. But they only protect you if you know they exist. And now, you know. Share this video with every senior you know. Share it with every adult child who has a parent in a nursing home or considering senior housing. Share it with everyone who has received a confusing medical bill or a surprise charge. This information belongs to all of them. Subscribe now so you never miss an update when new laws take effect or new enforcement actions are announced that could help you protect your money. And remember, this is educational content, not legal advice. For your specific situation, always consult a qualified attorney or a free senior legal aid organization in your area. Your money matters. Your rights matter. Do not let anyone take either from you.